Mr. Chief Justice, and may it please the court, my name is William Brown. I and my co-counsel, Abigail Moody, will be representing the respondents.
Students for fair admission sued the University of North Carolina, alleging that their use of race in the process of admissions violates the Equal Protection Clause in the 14th Amendment. We contend that race-conscious affirmative action is consistent with the text and history of the Equal Protection Clause of the 14th Amendment and in accordance with the precedents established by this court.
Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action, counsel?
According to the petitioners, the 14th Amendment and the Equal Protection Clause were written with the intent of prohibiting activities such as the use of race-conscious affirmative action in college admission policies. However, we contend that the amendment was written in response to the Black Codes, legislation that militated against the equality that was guaranteed by the 13th Amendment. The Black Codes intended to confine Black people to the bottom rung of the social ladder. After the Civil War, these laws intended to discriminate against Black people based on their skin color, not to their previous state of enslavement.
Furthermore, the court held that race-conscious affirmative action was in accordance with the 14th Amendment if it was used with the goal of educational diversity, which is supported by Grutter and Fisher II, without quotas, which is supported by Bach in Seattle School District, points, which is supported by Gratz, and without an educational benefit, Fisher I in Seattle School District.
Counsel, how does legislation enacted by Congress in the 1860s and 1870s affect your answer to question 1?
The petitioners fall short in realizing that not only would the framers of the 14th Amendment support UNC's use of race in college admissions, but they were the originators of affirmative action. The actions of the framers of the 14th Amendment reflect the true intentions of the 14th Amendment. Legislation enacted by the 39th Congress in the 1860s and 70s was the first situation in which race-conscious affirmative action was used. Not only was it used, but it was passed by the same Congress that had originally passed the 14th Amendment. Legislation such as the 1866 Freedmen's Bureau Act and the Civil Rights Acts of 1866 and 1870 all aided in understanding the intentions of the framers of the 14th Amendment. Those who supported these acts in the 14th Amendment saw them as consistent and complementary to the 14th Amendment.
So, counsel, let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
Although we live in a different society, the argument that race-conscious legislation is constitutional still holds true, although the argument may be formed slightly differently. This issue is much too complicated to just say that it needs to be gotten rid of, and to get rid of it. It is an issue that requires much more than that. We have seen that since Brown v. Board of Education, there has been much change. However, many of the basic principles that were considered when the issue concerning race-conscious legislation occurred still ring true today. We have seen that the way to go about handling this issue has changed, but the answer is definitely not to just get rid of discrimination on the basis of race entirely. It is a complicated issue that requires a complicated solution, and parts of that solution will stay the same over time, whereas others will change. The precedents which are already in place do not violate the 14th Amendment, and they also satisfy the decisions made in Brown v. Board of Education. There is not a good enough reason for the court to overturn these decades of precedent when institutions are following guidelines and their admissions processes hold up under strict scrutiny. Overturning precedent like this would lead to an upset of universities all over the country. Also, the things that these universities put in place of the use of narrowly tailored race might just make the situation worse. Universities, UNC especially, have sought out different ways to go about admissions without the use of race, and while these institutions are actively seeking solutions, a better solution has yet to be found. So although our society has changed, these decades of precedents cannot have a simple black and white solution, and these precedents cannot just be overturned, causing chaos within universities and the country.
Counsel, you brought up the case Brown versus Board of Education. Does Brown versus Board of Education prohibit race-conscious affirmative action? In your answer, please address Bach and Grutter.
The petitioners failed to show the context and reality presented in Brown v. Board of Education. The realities of racial segregation and dehumanization in question in Brown clearly made a mockery of the 14th Amendment. To compare it to the present day admission policies is insulting to those who were victims throughout pre-Brown America. The question presented in Brown v. Board of Education was whether it was acceptable for someone to be rejected from a public institution solely on the basis of race. Furthermore, they questioned whether students could be separated solely on the basis of race. Instead of rejecting or separating through race-conscious admission policies, UNC seeks to unify diverse students and bring them together, the true intention of Brown. One of this country's greatest attributes is its diversity. Brown v. Board of Education said that education is the foundation and cornerstone of a good citizen. Diversity is critical at a higher level because it prepares students for success in a diverse modern society. The court correctly established diversity as a compelling interest in Bach and Grutter because of its educational benefits. Bach established and Grutter reaffirmed that educational diversity is a compelling interest of the court. The value of educational diversity applied under strict scrutiny has been and should continue to be permissible by the court. UNC continues to work towards this goal of educational diversity with these race-conscious measures.
So, counsel, let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
The 39th Congress passed legislation to right the egregious wrong of slavery and aiding the newly freed blacks. The 14th Amendment protects individuals, not people groups. The Equal Protection Clause was written during a time when the need of newly freed slaves was in mind. However, the intent was so that anyone in that type of position could receive the help they need, especially in the area of education. Legislation was passed in the 1860s and 70s that benefited Black individuals due to the unique context of slavery. If any other individuals were enslaved and racially segregated from society, then the founders of the 14th Amendment would have provided legislation that aided those who were oppressed.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
Affirmative action is a drastic response, and gender identity and sexual orientation issues don't require this response. Justice O'Connor, in reference to Bach, stated that, quote, "We acknowledge that there are serious problems of justice connected to the idea of preference itself," end quote. The use of preference is a danger in and of itself. The use of preference should be reserved for drastic problems such as the issue of race. You can't use a drastic response such as affirmative action for every problem. Affirmative action used in this context does not hold up under strict scrutiny. You can't use affirmative action to right problems that are already being quickly resolved or have solutions that don't require affirmative action. The issue of gender identity and sexual orientation is an issue to which solutions have already been found. The Respect for Marriage Act is an example of this. The Respect for Marriage Act was passed to recognize the validity of same-sex and interracial marriage. Another example of this is that universities are already extremely welcoming to individuals within the realm of issues dealing with gender identity and sexual orientation. There are also classes within universities dealing with these topics. The issues of sexual orientation and gender identity are already being solved. Those arguing for gender identity and sexual orientation issues have already won. The debate is already over. There's no need to put measures in place for an issue that is already solved.
So, counsel, should Grutter versus Boehlinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs versus Jackson Women's Health Organization.
Grutter versus Boehlinger should not be overruled. This would only cause more chaos and division. In her dissent in Dobbs versus Jackson Women's Health Organization, Justice Kagan wrote, quote, "Stare decisis is the Latin phrase for a foundation stone of the rule of law, that things decided should stay decided unless there's a very good reason for the change. It is a doctrine of judicial modesty and humility," end quote. Stare decisis cannot be overturned because of just any problem. It must be a significant problem for which there is a very good reason for change. Stare decisis should only be overturned due to an egregious wrong. If stare decisis could be overturned at the drop of a hat, there would be no precedent for keeping decided cases decisions in place. This would cause complete chaos. Another thing to be considered is that the overturning of Grutter v. Boilinger would upset years of precedent in colleges around the country. Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak. Justice Alito, in his majority opinion, explained that there is no right to abortion found in the context of the Constitution or in the legal tradition of the United States, whereas affirmative action is rooted in the Constitution and legal tradition of the United States. The decision in Roe v. Wade has had damaging consequences, and far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. As addressed with the issue of allowing for affirmative action, exceptional circumstances call for exceptional measures. Roe v. Wade was an exceptional circumstance of abuse of judicial authority. The decision in Roe v. Wade only brought about more chaos and confusion rather than peace and unity. On the other hand, the decision in Grutter v. Boilinger is a decision that brings about more unity and allows for the aid of disadvantaged individuals. In conclusion, the overturning of Grutter v. Boilinger would only cause more chaos and confusion.
Counsel, in 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Race is a contentious subject now and in all of American history. The history of slavery and racial segregation has created tension in America since its very beginning. Just in the past years, there have been violent upheavals that were caused by issues linked with race. However, America is beginning to make progress toward a society in which race is not as contentious a subject. While race is still a contentious subject, we need the drastic effort of affirmative action to negate the drastic wrong of slavery and racial segregation. Affirmative action is a tool used to right egregious wrongs like slavery and to assure the promise of the 14th Amendment. However, when those wrongs have been righted, affirmative action is no longer needed. Justice O'Connor saying, quote, "We expect that 25 years from now, the use of racial preferences will no longer be needed to further the interest approved today," end quote, was an optimistic suggestion of a court that couldn't predict the future state of the country. However, it is not as simple as that. To put a steadfast time frame would be disingenuous to the mission of educational diversity. Another way to know when affirmative action is no longer needed is when affirmative action no longer needs to be used to promote educational diversity. UNC uses affirmative action under strict scrutiny to promote the court's compelling interest in educational diversity. UNC plans on continuing to use affirmative action with the court's consent as long as race-conscious affirmative action is needed to promote educational diversity.
Counsel, if the court declines to overrule Grutter, can the plaintiffs prevail?
No, Your Honor. UNC adheres to the ruling made in Grutter. Justice O'Connor wrote, quote, "In the context of its individualized inquiry into the possible diversity contributions of all applicants, the law school's race-conscious admissions program does not unduly harm non-minority applicants." End quote. The ruling in Grutter v. Boilinger determined that narrowly tailored use of race in admissions is acceptable. The law school also conducts a highly individualized review of these applicants. UNC adheres to this ruling. Their narrowly tailored use of race is acceptable under the ruling made in Grutter. They also conduct a highly individualized review of each applicant. These things are done in order to promote educational diversity, which flows from a diverse student body. In conclusion, if Grutter is not overturned, then UNC cannot lose the case because it shows that it adheres to the ruling made in Grutter.
Counsel, if the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
Diversity is not just important in education, but it's important in other institutions like the military. Grutter said, quote, "A highly qualified, racially diverse officer corps is essential to the military's ability to fulfill its principal mission to provide national security," end quote. However, this diverse officer corps and military do not come easily. One route that many officers go to become officers is through universities and ROTC. The military is unable to achieve a diverse officer corps unless service academies and universities are use race-conscious affirmative action.
Thank you, counsel. You may conclude your argument.
In conclusion, we contend that race-conscious affirmative action is consistent with the text and history of the Equal Protection Clause of the 14th Amendment and in accordance with the precedents established by this court. For the foregoing reasons, we respectfully request that the court find in favor of the University of North Carolina and rule that race-conscious affirmative action is consistent with the 14th Amendment to the United States Constitution.